The case announced today marks an important milestone in holding Canada accountable for failing to take reasonable measures to prevent Israel's genocidal campaign against the Palestinian people. Canada refuses to uphold the rule of law where Israel's armed forces are concerned. This refusal to act, in combination with Canada's bolstering of Israel's military capabilities, has had devastating consequences for Palestinian Canadians, including our clients. These consequences have engaged two of the most important legal instruments, the Convention on the Prevention and Punishment of the Crime of Genocide and the Canadian Charter of Rights and Freedoms. Our claim alleges that Canada, by failing to fulfill its legal duty to take all reasonable measures to prevent the crime of genocide against the Palestinian people in Gaza, did causally contribute to violations of our clients' rights under the Charter. I'll first share some background information on our clients. I'll then explain the importance of the Genocide Convention and the Charter, and then address the nexus between the two in this case. Our client, Hani al-Baghdadi, is a Canadian citizen and Palestinian Canadian born in Gaza. He escaped Gaza as a teenager in 1967 during the Israeli Army's raids. He later moved to Canada in 1989, residing here with his wife and children. On September 20th, 2023, Hani returned to Gaza for the first time. When Israel began bombing Gaza in early October 2023, Hani and his relatives fled from neighborhood to neighborhood, evading the attacks. They endured harrowing conditions and scarce resources. Despite multiple evacuation attempts coordinated through Global Affairs, Hani repeatedly faced setbacks and danger. After a near-fatal bombing injured him on November 6, he finally crossed into Egypt. Tragically, while in Cairo, he learned that several family members, including his niece and her young children, were killed in airstrikes. Hani later sought to bring surviving relatives to Canada under a special refugee program, but found himself ineligible due to his financial situation as a pensioner. Tamer Harada, a Palestinian Canadian from Calgary, moved to Canada in 2011, where he resides with his wife and two children. When Israel's attacks on Gaza began in October 2023, Mr. Harada was consumed with fear for his family's safety. Most of his relatives were sheltering in Gaza, but with each passing week his family grew smaller as his mother, father, two sisters, two nephews, an uncle and his wife, three cousins and their spouses, and children of two of those cousins were all killed in Israel's ongoing bombardment. In a desperate effort to save his surviving relatives, Mr. Harada applied on January 9, 2024 to bring 14 family members to Canada through a temporary resident visa program. While his sister and others managed to reach Egypt, bureaucratic delays and restrictive visa processing left most of his family stranded. As of August 19, 2024, of the 14 members he sponsored, only 2 of his spouse's unmarried siblings have been granted visas and were allowed to enter Canada. His family's situation remains precarious, while Tamer continues to grapple with trauma, unfulfilled Canadian assurances, and an uncertain future for his loved ones. The Genocide Convention is a cornerstone of customary international law, and as such is automatically adopted into Canadian common law as a means of combating the odious scourge that is genocide. The duty to prevent genocide is enshrined in Article 3 of the Genocide Convention, and it imposes a legal duty on states to act within their capabilities and to take all reasonable measures to prevent genocide when there are grounds to believe that it could occur. The duty is so important that it prevails over conflicting treaties or domestic law, thus reflecting the international community's recognition that it is imperative to prevent this crime of all crimes. Canada, as a party to the Genocide Convention, has a legal duty to act within its capabilities to prevent genocide when there's reasonable grounds to believe that it could occur. In this context, Canada's duty to prevent genocide compelled it to take all reasonable actions within its power to stop the assault on Gaza. Although Canada hasn't always succeeded in preventing genocide, it has a well-established track record of trying to do so by taking meaningful actions against perpetrators and providing meaningful support to victims. But instead, as has been outlined by my colleague Mr. Lascaris, over the past year, Canada has taken no meaningful action to exert diplomatic, economic, or military influence over Israel, even while hundreds of Palestinian Canadians, including Mr. al-Baghdadi, desperately tried to escape Israel's indiscriminate bombing of Gaza. Canada took no action to restrain Israel. Worse still, it facilitated record levels of arms exports, engaged in military cooperation, allowed groups in Canada to recruit volunteers for the Israeli military, and failed to stop organizations with charitable status from subsidizing the operations of Israel's Ministry of Defense. Canada's actions and omissions towards a plausible campaign by Israel to destroy the Palestinian people of Gaza violated its duty to prevent the crime of genocide, a duty imposed on it by the common law and the Genocide Convention. The Charter forms part of Canada's Constitution and protects the civil rights of Canadians against government action. Sections 7 and 15 of the Charter are engaged by this claim. Section 7 of the Charter provides that everyone has the right to life, liberty, and security of the person, and not to be deprived thereof, except in accordance with the principles of fundamental justice. The guarantee of fundamental justice applies to deprivations of security of the person by foreign state actors if there's sufficient causal connection between Canada's conduct and the deprivation. This does not require direct causation, but rather a meaningful or substantial link between Canada's actions and the harm suffered, where the harm is a foreseeable consequence. Mr. El-Baghdadi claims that Canada's failure to take all reasonable measures within its power to prevent Israel from committing the crime of genocide against the Palestinian people, in addition to its collaboration with Israel, contributed to a deprivation of physical and psychological security of the person while he was attempting to survive and escape Israel's military bombardment of Gaza. Section 15 of the Charter provides that every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination. The claim alleges that Canada discriminated against Mr. El-Baghdadi and Mr. Harada in two ways. First, Canada discriminated against Mr. El-Baghdadi when it failed to take all reasonable measures within its power to prevent Israel from committing the crime of genocide, arbitrarily departing from its history of fulfilling that duty in other plausible cases. Second, Canada discriminated against Mr. El-Baghdadi and Mr. Harada when it denied them access to reasonably functional immigration and evacuation programs such as those it provides to Canadians seeking refuge for themselves or family members from other parts of the world. Canada's conduct was based in whole or in part on Mr. El-Baghdadi and Mr. Harada's race, religion, or ethnic or national origin as Palestinians and Muslims. In closing, Canada's failure to fulfill its duty to prevent genocide, even amidst glaring warning signs, is an omission of such egregiousness that it would shock the conscience of Canadians. Such shock would be compounded further by the fact that Canada maintained its course of conduct in the face of full knowledge of the potential risks. And for these reasons, the Coalition for Canadian Accountability in Gaza has filed this claim seeking declarations from the Ontario Superior Court that Canada has failed these duties and has violated the rights of Mr. El-Baghdadi and Mr. Harada.